We are very lucky to have Artemis Malekpour here today to read today's tip from Damages Evolving. Welcome, Artemis.
Thank you so much. I appreciate it. So even if you don't get voir dire and cannot research the online information in time to use for jury selection purposes, there's still great benefit to using knowledge of who your jurors are and what matters to them in shaping your arguments and analogies throughout trial.
So even if you're not using information about the jurors in selecting them or creating a tribe or however you do jury selection, you can use that throughout trial. So I'm very curious. I know I bet you've worked with thousands at least of potential jurors and focus group participants in the work that you do with David Ball. What do you mean by this? How are we going to use that throughout trial information about jurors?
So ideally, what we would like is you be able to get your jury list beforehand, and to be able to research your jurors, not in any kind of creepy way. Don't friend them on Facebook. Don't, like them. Make sure on LinkedIn they can see, if some people can have that premium thing where they can see someone's researched them. So you got to be really careful of how you do it. But it's certainly appropriate to do some research of folks online because you get a better sense of who they are. And you can do that before you get into the courtroom if you get that jury list in advance, or sometimes you can do it while in the middle of jury selection, have a team who's researching your jurors. But sometimes you get 15 minutes. You don't get the list beforehand and you get, 15, 20 minutes of voir dire. So we'll have folks who won't actually bother to look up who their jurors are because they've already picked the juror. So they figure, well, what good does that do me now? Well, it can do you a tremendous amount of good because those are your decision makers. And you need to know, even though they're already in the box, you need to know how to present your case so it matters to them. Trying to get them to care about your client isn't always effective. But certainly if you know what they care about, where their world is, things that they like to do, where they work, experiences that they've had, and especially if you didn't get that, you weren't able to have that conversation with them in voir dire, this is a great way to do the research and be able to try your case, frame it, shape it in a way with your experts, with the arguments that they use, with your openings, with your closings, in a way that those jurors can see how this case and the verdict affects them. So it allows them to have now a stake in this case, and it's an important decision for them, and now they care about what happens.
That makes a lot of sense. So you're looking at, ideally, if you can talk about in jury selection, but if you can't, it sounds to me like you're trying to see what do your jurors value and how to speak to those values, right?
What they value, how much they value it, how does it, for the folks that, when they're not able to do it anymore, and how much time they put into it, how much time they invest in it, all those things, it speaks to your damages case, absolutely, and how much the value that they put, so if it was taken away, how much they care about it. But it also does go to your liability in places they work. Do they have safety rules? Are they on the road? Do they travel a lot? Do they drive a lot? Are they in certain neighborhoods, that kind of zone of danger? All those things, it's important to know, okay, when I've got this witness on the stand, how is this witness, the information that they give, going to hit those jurors? How's it going to resonate with those jurors, and what's going to make those jurors actually care to listen and then to do something about it? And it's empowering your jurors, but you're not able to do that if you don't know who those jurors are. And it's really important. Unfortunately, too many times, even if you do get that research beforehand, even if you get the names beforehand, even if you know who those jurors are, too often attorneys forget who they're trying the case in front of. It's not the judge, it's not to the defense attorney, it's not to the crowd or your friends in the back who came to visit, but it is those jurors in the box, and they're the most important people in that courtroom. And if you're not presenting a case in a way that matters to them, then you've really kind of, you've lost a huge element that can help you win your case.
Today's tip comes from Damages Evolving, and we have Artemis Malekpour here to read it for us.
Thank you. No matter what your clients say, there's a good chance that they've agonized over what part they may have played in their injuries or their loved ones' wrongful deaths. It's a vulnerability that the defense can sniff out while you never knew it was there. So whether voiced or not, always consider it a concern that you need to address directly with your client well before the defense can take an advantage.
Wow, this is something that I think a lot of lawyers just ignore, and it's really important to talk about. So how do we deal with that? Let's say an extreme where a parent says, "Oh, if only I hadn't invited Junior over to have pizza that night, he wouldn't have been on the road and been killed." I think most lawyers say, "Oh, no, 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 no," like they want to fix it or not deal with it. What's a more skillful way to deal with that?
Well, first, you're lucky if your client does admit to it, because sometimes your client won't even admit to it. It just sits there with them and they don't even want to admit it to themselves that they have guilt about it, that, oh, if I had only done this. So certainly if your client voices it, you want to absolutely deal with it, because if the client believes this, certainly your jurors are going to deal with it, and then it's going to also come up in depositions. But if your client doesn't voice that guilt and you think, well, the defense isn't going to go there, the defense says your client's not on the verdict form, that doesn't matter. It still will somehow seep through how your client talks about what happened, how your client deals with, sometimes, we see clients who get really, they kind of shut down, or they don't seem to express emotion. It's almost like a defense mechanism. So how your client ends up talking about things, if they're super weepy and jurors don't understand what that's about, if they get defensive with the defense attorney, they're combative, aggressive, all those things. What's driving that? What's behind that? And often it's because they haven't settled this in themselves to feel like I've cleansed myself, if I know I did everything I could have done. And because they haven't, they don't feel that they've come to terms with it within their own selves, then it becomes difficult for them to express themselves truly and to really point the finger where it should be in terms of what the defense did wrong. So you've got to get that, you've got to deal with it. And whether it's whether it's in your office, out of your office, in their home, maybe you're not the one who can deal with it, depending on who you are and what kind of attorney you are and how much empathy and how much ability you have to relate to a client. Maybe it's someone else on your trial team who does it, but someone has to have that conversation with your client in a trusted, warm, protective environment to be able to pull that out and for them to express all the grief and all the anxiety that they themselves feel about what happened. So again, the focus can turn in trial and in their depositions towards the actual wrongdoers.
Wow. So no shortcuts to that. It's really spending a lot of time with your client, learning their story. And if you can't do that, to find those few great experts out there who can.
And knowing how to ask or how to approach the subject with this, it's not a cookie cutter, one size fits all for every person. I mean, for some people, just being able to sit in their house and then for you to come at them with some compassion can open up the floodgates. For other people, it can shut them down. So it's really and that's part of why we say you must spend time with your client and get to know who your client is, to be able to know how to talk with them and in a way that gets information from them that they feel comfortable sharing. And again, it may not be you who's in the position to do that, but it has to be someone on your team to be able to, before the defense takes advantage. And even though your client is not on the verdict form, jurors can still potentially blame your client, especially, and we know with defensive or negative attribution, that idea that I would have done better, I would have protected, my loved one better, this would never have happened to me, if we know jurors will do that, we got to know that the client's doing that as well. So how do we take that and then focus it, put it in, take it, as Gary Johnson would call that, kind of judo law, turn it against the defense. So now it becomes a strength of ours as opposed to a weakness that we have to deal with.
Today's tip comes from the classic David Ball on Damages, written by David Ball, of course. And here we have David to read the tip today. Good morning, David.
And how are you today? I hope you're well.
Very much so. Thank you.
This says, good lawyers sound like people, not like lawyers. Good voir dire is conducted by lawyers who sound like people, because jurors more easily talk to people than to lawyers.
Yes, this is very wise. That when we talk, we're trial lawyers, not contract lawyers. When trial lawyers talk to people, you want to sound not like you expect a lawyer to sound like. I bet you have some stories you could tell about this.
Well, I mean, my favorite description in this is when people get afraid of clowns, why do you dress up like a clown? This is the same thing. Lawyers are the butts of jokes. Lawyers are the objects of all kinds of anti-lawyer, anti-plaintiff, anti-lawyer biases. Until they get to know you a little bit, you are no exception to the stereotypes and the biases and suspicion is there. Plus, in voir dire, if you want them to open up a little bit, they're not going to open up to people that make them uncomfortable. They're not going to open up to people who are being formal. They're not going to open up to people unless you open it up. And the best way to do that is to talk like people. How do you talk when you are out in public and really want to have a conversation with somebody? You don't come up to them holding a clipboard in one hand and a piece of pencil in the other hand and talking legalese and sounding like a lawyer and in your lawyer important voice. You talk like a normal person. And that doesn't mean you need to sound negative in any way at all. You just, as Jerry Lewis used to say, talk regular. You talk like a normal human being talks if you want people to relate to you like a normal human being. And that is the only kind of being with which you can establish any kind of rapport with jurors. And then you listen. You don't just sound like people. You listen like people who really want to hear what that prospective juror has to say. So all this is saying is, stop being a lawyer during voir dire, actually during the whole trial. Be a human being first.
I love this. And I love that you've made the distinction. It's not just the words. Of course, we don't build rapport by saying, will you follow the preponderance of the evidence? There are horrible things like that. But it's also more subtle than that. It's what I see a lot of lawyers when they're, let's say, practicing an opening. That first second is so important. I see so many lawyers just switch into lawyer mode. May it please the court. All of a sudden, they put that on versus when you really watch lawyers who have been successful, most of them are talking with the jury, not condescending to, talking with.
And some folks feel like they have to do the little thing for the judge, may it please the court. That's okay, but that's for the court. And that's a little formality, and you do it towards the judge. Now you come to the jury and talk to the jury. Okay, so you can fulfill your function, your insofar as there is any such thing. It's like saying, get that out of the record, or for the record, give me your name. Well, they already have your name. It's not, but there's a lot of nonsense like that. And I'm not sure that may it please the court and that sort of thing is always nonsense. There may be some places where you have to say that, or some judges who like to hear it. But to differentiate that, talking to the judge and talk to these folks, get your pleasure out of those folks. A wonderful trial consultant named Diane Wiley, who was with the National Jury Project, I think she still is, said years ago that you have to convince yourself that you enjoy doing voir dire. In other words, it's a privilege, it's a pleasure, it's nice to be able to connect with people like this. Find some pleasure in that so that you're losing yourself in the pleasure and not sitting there saying, which one of these damn people do I have to get rid of? Aha, did you file a lawsuit after that wreck? Get out of that.
Wow. No, it's a good suggestion. And, you talk about differentiation, and I think it is important to say that we can't make every moment the absolute most wonderful moment possible. There's some things we have to do as lawyers, and I try to differentiate those. So, for example, I might say, now let me ask you a question, which I'm required to ask in order for us to, do my job. Is this photo a fair and accurate representation of the way it looked at the time? So now I'm at least, if I have to use that legal language, it's understandable why I'm doing it.
And don't say boilerplate things that are not going to be true. I'm not here to pry, and then go ahead and pry. You can say, I hate to sound like I'm prying with you, but I'm required to find this out. That's different from saying, we're not going to pry. You can relax about that now. Did you really hate your mother? Don't set up that. Don't make yourself a liar in that little short section that the first impression they get of you. You want their impression to be, this is a person I can relate to. The other really important point here is if you want these jurors to think that you care about human beings the way you're professing to care about your client, there is no better way to convince people that you care about them than to listen to them. One of my great weaknesses, that you listen to them. I listen, but I don't let people know that. You need to let them know that you don't have to do anything. Just look at them, not as appropriate. Don't get boilerplate things. If somebody says something terrible happened to them, acknowledge it, even if it's an "oh" or a "I'm sorry that happened." But these formal thank you for your candor is not a good thing to say, because some people feel like candor is a sexual act. They don't know what that word means. Thanks for talking about that. It's much more human. Be the human being that you are, the part of that human being that you are, that you want the jurors to perceive you as. And it's especially important in voir dire because you need them to be comfortable enough to tell you things that they think you might not like. What else is there to voir dire?
Today's tip comes from Theater Tips and Strategies for Jury Trials by David Ball. Here to read the tip is David Ball.
This says, build your case from low intensity up to maximum impact. Use the same pattern in rising intensity within each separate segment of your trial presentation. Each witness, each section of testimony, each story you tell in your opening, each argument.
Wow. So rising intensity makes sense to me. And it also makes sense to me to start strong, end strong. Maybe that's different than intensity. How do I square that?
I want to talk about that a little. You do need something strong at the beginning, but you don't want jurors to feel that that's it. That's as interesting as this is going to get. That's as big as this is going to get. You want them always to feel that this is going someplace. It's an old rule of theater and film and other kinds of things like that. That the minute jurors feel that things are getting less interesting, they start spending less of their attention on it. and their mind wanders to things they'd rather. You want to arise, whether it's within a single witness's testimony. Doesn't mean to start with something trivial. It doesn't mean trivial stuff. You don't want any trivial stuff anyplace, but you want something to build. Now, this is from an old book in its third edition. It was originally published by Nita, and then Trial Guides, bless them, bought up all my books and moved them at the time to Trial Guides. But this, which tells me when I look at who published this version of it, that this goes back quite a ways. However, it's still extremely important advice. There's a wonderful play called Arsenic and Old Lace. Great comedy. The problem with it is its first 3 minutes might be the funniest 3 minutes anybody's ever written for the stage. And if you direct it so that it comes out that funny, then everything that follows seems slightly puny by comparison. You don't want that to happen with your case. You want some kind of overall view that this thing is going closer and closer. And I'm talking about your case. You can let all that go by the time the defense goes up to do their case. So yes, as you're arranging your sequence of witnesses, one of the characteristics to take into account is interest and intensity level of each witness. If there's somebody they're all looking forward to, put them later in the case, if you can. Now, don't sacrifice the logic or the other kinds of persuasiveness. But one of the guidelines to keep in mind is we're trying to build so that there's a reason to hold juror attention. Because we know that when you don't do anything, just let that happen, that jurors only hear about 20% of what's going on. That's not enough when you've got the burden, and it is a gift to the defense.
Wow, thank you. I've often thought about, again, the interest with start strong, end strong, and I love the idea of actually measuring or making notes of interest and intensity, and intentionally planning the witness order and within each witness's testimony, the intensity and interest, to keep that in mind.
There's a wonderful play by Moliere called Tartuffe. The main character is Tartuffe, and he's a religious hypocrite, and it's one of the great plays ever written, great comedy and great serious. He doesn't come on stage for the first third of the play. People talk about him all the time. They're to the point where the audience is dying to see this character. Well, if you have a client like that, or a witness like that, or something like that, that you create the promise of, this is simply basic theater technique. My Trial Guide sells a book of mine called Backwards and Forward, which will teach you how to use a lot of the methods of how we structure plays to hold attention all the way through. And that's really all this is. This is saying you want the jurors always looking forward to something that's coming up, not just to settle on what's here in this moment.
Today's tip comes from Damages Evolving, and we have a special guest. David Ball himself is here to read us the tip. Good morning, David.
And how are you, Michael?
Wonderful. What great wisdom do you have for us today?
This is about freedom. This one's about freedom. Freedom, this is a quote from the book. Freedom to control our choices is precious. Its loss is a powerful damages driver. Losses of freedom frame the harms in a context that jurors easily relate to themselves and empathize with. And losses of freedoms show the injury's greater consequences. What I think I mean by that, what I know I mean by it, is the more you can find ways to relate the losses directly to who the juror is, and not ask them to make a conscious cognitive leap. For example, you'll say, she lost her ability to plant her beloved tulips every spring. That meant everything to her. I don't care what you say or do after that. Nobody cares about her petunias. They just don't. And when you say, try to imagine what it'd be like to lose the thing a person found the most precious to themselves. and I'm still thinking petunias or golf or lifting up their grandchild. Who cares? I have no grandchildren. I don't like petunias, and I'm certainly not going to play golf. And that's how jurists sit there listening to this stuff. It's all cognitive. It's the top part of the brain. That's not your great damages driver. You want to get something working in there that says, my God, we cannot let that happen to human beings. It becomes an immediate threat. If you hear there's been a murder across town, that's terrible, and you don't like it, but it has nowhere near the impact as if you found out the murder was in the house next door to you. And that's the bridge we're trying to cross here. That's the link we're trying to combine. So when you say she's lost the freedom to be able to choose to go plant her petunias that afternoon, it is very precious to her. It might be somebody else that might feel that way about their grandchildren. Somebody might feel that way about going to work, that whatever it is, if you don't have the freedom to do it, if they took away your freedom to get up and walk across the room when you want to, if you frame every loss like that as a loss of freedom, a loss of your free choice, that is a huge loss. Look at what just happened with the whole COVID vaccine. People who didn't really worry about the consequences of the vaccine got all heated up about this thing of, you're taking away my freedom to control my body. Don't particularly want to allow that freedom necessarily to women who would like to have an abortion, but nonetheless, it is a matter of free choice, which is a very precious thing to most cultures in America. There are very few that don't find that very powerful. And of course, it's inbred in us because our brains are so attuned to making choices with whatever context we're in, that the important choices are the ones that are ours. I will pick up a gun and go fight a battle for something that is important to me. Whereas if I'm forced to pick up a gun and go fight a battle for something that's just important to some leaders or some great powers, I ain't the same soldier. We're witnessing this, as of this recording, which might be a little bit earlier than the day, in the Ukraine, where Russia's sending in troops who don't see really why they're there, which is one of the reasons the Ukraine is so far managing to survive. It's always true. The only thing that keeps those soldiers moving is they're going to get shot in the head if they don't do it. Think back through all history, those horrible kinds of battles they had. Whereas every so often somebody comes along like Henry V and talks to people and says, here's why you want to participate in this, whatever it is. That's what good coaches do in the locker room. They talk about what is important to you. You don't want to lose this. You want to gain that. Well, freedom is an automatic for most Americans. It relates your petunias to my whatever it is that is important to me. I don't even need to make that leap. Freedom in itself to choose is a very powerful driver, and I will feel empathy for the person who's lost it. And it's frankly hard for me to feel empathy with a person I don't know for not being able to pick up a grandchild I don't know, or not being able to play golf or plant your petunias. That's what this point is about.
So it's not the activity. There's always going to be an activity, a functional loss, and maybe a juror will relate to that. Maybe not. Maybe they hate golf. Maybe they like golf. Maybe they like petunias or not. But what everyone will relate to, and you have to get those stories out in direct, but then what the jurors will relate to, if I'm understanding you right, is not that they can't play golf, but they took away the choice that that person had when they were able-bodied. They took away from them the choice of doing what they love and fill in the blank.
Yeah, so this comes out of countless jurors having told us in post-trial interviews, or we hear it in focus groups all the time. So they can't read anymore. Watch television. I watch television. I'm not complaining. I'm not asking anybody to give me millions of dollars. And you can't criticize those people. They don't understand that loss. The most they can do is make a cognitive, conscious leap out of their parts of their brain that drive their decision making and into their conscious brain that has almost nothing to do with driving their decision making. That sounds weird, but we know that's true. No? By the time you're thinking about what choice to make consciously, the rest of your brain's pretty much already made the choice. We want to get to that part of the brain. That's where the empathy comes from that makes us feel things, that drives what we do. Even if you're not a very empathic person, it still gets there, because even not very many empathic, they still have that drive when it is something that relates to them. Oh my God, the poor, look, if I planted petunias and understood that, I would say, oh my God, the poor woman, give her everything she's asking for. She can't plant petunias anymore, because that's automatic. I empathize with that loss. I know what it's like that somebody grabs my petunias. I know what it's like when somebody grabs my freedom. And so do most jurors. And so now you've got a great driver. It's a positive driver, and it is an honest driver. There's no gimmick about this whatsoever.
Today's tip comes from Theater Tips and Strategies for Jury Trials by the one and only David Ball, who's here with us today. Good morning, David.
How are you today?
Wonderful. Thanks.
This one says, it's easy to gain the reputation of being an attorney who prefers to settle rather than go into battle. Don't let such a reputation attach to you. Instead, develop a reputation as a trial lawyer who loves above all things to go to trial. When your opponent can tell her client how eager you are to get the case in front of a jury, it helps with negotiations.
Right. And one of the best ways to develop a reputation as a trial lawyer who loves to go to trial is actually to be a trial lawyer who loves to go to trial.
Yes, obviously. The computer that they have, what do they call the thing? Not ubiquitous, whatever it's called. Ulysses, well, I forgot that. There's this big computer that all the insurance companies have access to. They can tell on the push of a couple of buttons your frequency of settling.
Oh, the Colossus, I think.
Colossus is one of those, yeah. Hey, I just think it deprives people of their day in trial. But more importantly, if I'm the decider for the defense, and I see that you usually decide not to go to trial, I'm not going to work very hard to satisfy you, to get you to avoid trial. Why should I? You're probably going to want to avoid it anyway, and so you probably will suppress lower what I have to do to get there. I want them to think that you will be horribly disappointed if you can't take this case to trial. That you are, and preferably your client as well, if you can get there. That's your heart's desire, is to get this in front of a jury. So they have to pay for the privilege of taking away something you want. That's the principle here.
It makes sense. I remember early in my career, someone saying to me, if you prepare to settle, you may go to trial. If you prepare for trial, you increase your chances of settling. And certainly what you're bringing up, the reputation that you have, we know insurance companies consider that without question.
Well, it's like you have to decide, do you want to be McDonald's or do you want to be Cuisine? You can do a million cases and settle them all alone. And unfortunately, we all know there are mills that do exactly that. And I think they're a terrible disservice. The clients don't do as well. You don't need to do as well because you're doing 10 of these for every one that you might take to trial. And I suppose you have to do that in some economic situations. But I would hope there are people out there, I know there are people out there working them all the time, who are chomping at the bit to take the damn case to trial. I mean, I've been on the phone with people who were ultimately so frustrated because it finally came in an offer that that just couldn't be refused, which is, of course, what you're ultimately after if you're going to mediate, and not just a way out of this so you can bounce on to the next one. but be real careful about not letting yourself become one of the ones who that one's like pretty. You can hear the conversations going on in the insurance companies. You don't worry about him, he settles, which I think is the worst thing that can be said about a trial lawyer.
That's a lawyer who settles. Yes, that's not something.
Too easy. Nothing wrong with settling. You've got to do what your client wants, et cetera, et cetera, et cetera. But when you become known as somebody who's actually working in the direction of settling, rather than working in the direction of, if I have my druthers, we're taking this baby to trial, because that's what I do. Now, if you don't want me to do that, it's going to cost.
Today's tip comes from David Ball, who's here with us. Hello, David.
How are you today, Michael?
Would you please read? I'm doing great. And I'll be even better after you read your tip from David Ball on Damages 3, please.
I will do it. Verdict size is influenced by how jurors feel about the plaintiff or the plaintiff's family. Jurors who like the plaintiff or consider the plaintiff's family good folks tend to give more money. That should not discourage you from taking clients who are not automatically good folks. What you need to do instead is learn ways to make the humanity, the decency, the parts of your clients and their family that are good, and there will always be some. I think I've worked on 2 cases in 31 years, and I'm a consultant, so I work on a lot more cases than lawyers do. Not because I'm better than lawyers, but I don't need thousands of hours, there's hundreds of hours to put into one case. But you can always find the good. What do they do? I don't care if all they do is pay their taxes on time, but they do something good. How hard do they have to work to pay their taxes on time? So always look, including when they're automatically good folks, for the things that will resonate with the jurors about what makes these people worthwhile. Oh, grant you, sometimes that can't be done, but it's very, very rare, and it usually just means you haven't looked hard enough. Sometimes you have a thoroughly unattractive person, I don't mean physically. Sometimes you have a person who, by stereotype, an illegal immigrant or something like that. For years, it was the welfare mom, things like that. And what you would do is you look for things about that person that are exceptions to the stereotype. So you take whatever the stereotype is, like of an illegal immigrant, they do this, they steal our money, they steal our jobs, they send all their money back to Mexico or wherever they're from, and they hide things or they stick to themselves in little groups and all that stuff. And you find, what is the exceptions about what your clients? So there's something they can admire. You use the surround about them as a negative force that they rise above somehow. This can take some creative thinking, but the primary question of every juror is, why would I give money here? Why would I allow money for a verdict? I mean, hell, money for pain ain't going to do any good. It's just to compensate. Why would I want to shift that money from one place to another place? Well, if they're not good folks, I really don't want to do it. So you need to find things they can give themselves a reason to do it, or that can get in your way and just push the damages right on down. And it's a shame how often that happens. And most of the time when it happens, it's because plaintiff's counsel allowed it to happen. They allowed the other thing that plays in here is, you may love your client, but you've known your client for a year or 2. The jury gets these brief glimpses of them sitting at the table. Maybe they testify. So they're seeing from a totally different point of view. So what are they going to see? And I can't tell you. I used to do jury focus groups before. I partnered with Artemis, who does our focus groups for us, Artemis Malekpour, and she does the partnerships focus groups. But when I did them, every so often, I would bring the client in and cross-examine them live. And I can't tell you how many cases in the focus group, you can tell we're on the rise. The jurors love this case. And in comes the client, and they just didn't like the way the client was dressed, or the jewelry, or the suit, or whatever, stuff they didn't like. And that was great because we can find out what it was and do something about it. But when they don't like what's there, they tend to trust the client less, and therefore they trust you less. Because if I look at your client and think, I don't trust that person, or I don't think they're deserving, and then I hear you saying the opposite, I start to distrust you and that you don't deserve to have a client who makes a bunch of money. So this is a very serious problem, and people just don't pay it enough attention. Don't fret about it. Don't say, oh my God, I've got the worst clients in the world. Learn. The book has stuff on it. A bunch of lawyers out there have stuff on it. Many listservs you can get advice on. People you've seen teach whose work you like. All of them, they won't mind it. They'll be flattered. What do I do with this? And you'll get ideas, but don't panic about it. It's no different than dealing with a complex law in a case. You don't say, oh my God, that law is too complex for me to deal with. Neither is this. And I really suggest you tend to it well.
And I love what you're saying, because I feel like one of the things I love the most about my job, and when I'm really doing it well, and it takes a lot of time and effort, but that's finding the good in my client and bringing that to trial. And it also requires us to have a trust in the jury, right? That they will relate to that good. But like you said, there's some clients it's easier to find than others. And it's there. You're right. Maybe 1 in 30 years or something. You said, I could give an example that comes to mind, but short of that, there's always some good to find. And that's our job as plaintiffs, trial lawyers, to get in and spend the time and find it. It's not something a paralegal can do. You got to do it yourself.
Some gifted paralegals can handle that for you. Then you're not the same when you're doing it in front of the jury. One of the things jury voir dire is for you to learn about some of the values and preferences of the juror, because that's a guide for what to look for in your client. Find those cross things. Remember, it is not what works for you. You're a lawyer, a very specialized, I say with all due respect, narrow point of view. That's going to be different from the 6 or 12 folks you've got. So voir dire, or a lifetime of doing voir dires, if you get to do them, and focus groups all the time. Go to focus groups. I don't care if they're not for your cases. Get your lawyer friends who allow you to go watch theirs, and you learn more and more and more about what is important to jurors, especially in the area that you practice in. I mean in the location you're practicing. It's another bridge building thing. The law is not about you demonstrating something for your client. The law is about creating a group of people who are going to work with you to do what your client needs done for you.
Today's tip comes from David Ball's Theater Tips and Strategies for Jury Trials. And we have David here to read the tip. Welcome, David.
Welcome to you to our little discussion here. This is from Theater Tips and Strategies for Jury Trials. It says on the cover, Anita, the National Institute for Trial Advocacy, but about 15 years ago, Trial Guides bought all of my stuff and brought it over to Trial Guides. So where you get this, if you want this book, is from Trial Guides. And this is the quote. The single most important task in trial is to give your favorable jurors tools designed for their use, not yours, words and phrases they can easily use, concepts they can easily convey, and plain language responses to every argument they're likely to encounter from opposition jurors. This is based on the fact that you are engaged in a very weird business. You're not just engaged in the task of making up other people's minds for them, of making them make the decision you want them to make. That's hard enough. But now, once they've come your way, you need them to be able to go into deliberations and pick up the torch from you and fight the battles for you. You can't be in there. That's really the whole purpose of trial. I need to get whoever will go along with me to go in there and fight the battle. So just a quick example. This is not the only way to do it. You'll say to them in closing, if somebody says during deliberations, they think such and such a thing, remind them such and such the other thing, and say it briefly in a boiled down phrase that they can remember. Find ways to say it 2 or 3 times. Say, if you're taking notes, you might want to write this down because you're probably going to need it in deliberations. So that when they go in there, they're ready to pick up the torch. And the reason this is so important is A, you can't be in there. B, once I, as juror number 3, I'm convinced, that doesn't mean I can go in and argue and convince anybody else. Once you give me those words and phrases, I can and I will. And once I have made those arguments for you, I am much less likely to fold because now I've laid my opinions on the table. Now it's much harder for them to get me to go along with the other side. So this is important on several different layers, not including the ones I just talked about, but others as well. It makes your jurors your active advocates and not just people who sat back passively being convinced, go in the other room, see how the other people feel, let's come to a decision and get the hell out of here. It's the last thing you want from jurors. They'll compromise on every damn thing in the world. If somebody says $1 million is a lot of money, remind them a lifetime of pain is 10 times that a lot of money. So now you've anchored your verdict with a figure in million, and you made an argument. You want to but the juror take it and use that argument. But the pain, and another juror says, $1 million is a lot of money, which still may be one of the most common phrases jurors ever say. Or if it's a smaller case, 100,000 is a lot of money, or bigger, whatever. It varies. But you give the jurors any important thing in your case that you have not boiled down and made simple, not for them to understand and not to be persuasive. Yes, they have to be that, of course, but to also frame it in a way that it goes right into the jurors' ears and will come out their mouths in deliberations. That's probably the ultimate goal of all advocacy. Because if you don't do that, I don't care how much you've persuaded a juror. That doesn't make them a good advocate for you and your client in deliberations.
David, there's so much important in there, educating the jurors to advocate for you, and also the plain language. I don't know how you can't emphasize that enough. And lawyers will hear this, and still, for me, I feel like I become a better and better lawyer the less law I'm speaking and the more plain language. It's not to speak down to people, but when we start with the plaintiff alleged this or the defendant did that, people don't even know what plaintiffs and defendants are. We want to say that Jane and we want to say ABC Trucking Company. I feel strongly about those things. I'm sure you have all kinds of examples.
Well, almost anything. They don't know what negligence is. I mean, face it, neither did you before you went to law school, and maybe not even then for a while. They don't know these things. Why should they know? It's not that they're stupid. They didn't go to law school. You can't do what they do in their everyday lives. It doesn't make them dumb, but you want plain English, of course. It's one of the biggest complaints I hear both from jurors and, by the way, from judges. Judges do not like legalese in your damn briefs and motions. They just don't, if they have to read them. I mean, as one judge said to me, I got to read this stuff. So yes, you're absolutely right there. But what we're really doing now is it's not just get rid of the legalese. It's make the language in simple sentences, not because they're stupid, but because you want them to remember them. Where you can start doing this is much earlier in trial. You can ask your experts to say, these folks are going to need this concept when they get to deliberations. So would you mind saying that again or explaining that a slightly different way or for the lay person's ear? And that does two things. One, it gets the experts say to be more juror friendly in how he or she speaks, but also it reminds the jurors they're going to have to go in and fight for you. It tells them that early on Otherwise, you get people who never thought for a minute about that we're going to have to make a decision later. That never crosses their minds. I'm never going to have, it doesn't occur to them to talk to other people. When you remind them of that, and you can't say later at the end, you're going to go deliberate. That doesn't do it. When you tell them specifically what they're going to have to do, you're going to need this to explain to each other when you get to deliberation. So to use when you talk to each other, that tells them something they're interested in. And if they're taking notes, you will see some of them writing down.
Today's tip comes from the classic David Ball on damages. If you don't have this book, go out and order it now. And we also have with us the classic David Ball himself to read today's tip. Hello, David.
How are you? Feeling very classic. I should have worn my classical clothing. And I should read this now. I'm going to read this to you all. Okay. Jurors cannot gauge the full weight of the harm unless you get them to walk in your client's shoes. If you do not, they measure the harm by how it feels to an observer, not to the harmed person. What that means is there is no greater pain in the world than mine. And there is no lesser pain than someone else's, unless it happens to be someone you're very, very close to. Pain is a peculiar beast. People actually have less empathy for pain than they do for a lot of other things that your client has lost. Anxiety is worse. Being alone, being lonely, being stuck in one place. And pain does not register as high as we think it does on the empathy scale. And that might be because it's very hard to find people who never have any pain. It's common to everybody. The knee-jerk reaction is, well, I'm in pain, or my mother's in pain, or whatever, and nobody's giving her all that money. Until you get them to identify personally with what it is like now to be that person, what that does to their lives, how it feels to be them. You've got to be very careful doing this because you don't want to violate the golden rule by saying to the jurors, how much money would you want if this happened to you? However, you can say, this is how it feels to be who she is when she has to measure how much pain she can take before she gets up to walk across the room, for example. Another really good way to do this is, if you've been to the Spence Ranch, they and other people teach a way of telling that story as a first-person account through your client's eyes. And there are some excellent examples of that. I would caution you, if you use a first-person narrative, to make sure you test it in focus groups or with other people, because sometimes you can really alienate a jury by doing it. And I don't know how to generalize which ones work and which ones don't. But I've known those personal first-person narratives actually lose cases for people. However, if you can make it work, if you can test it, if you're comfortable with it, it's very powerful. Any way you conceive of doing this, if they have to wear a brace of some sort that's painful to wear, pass it around the jury. Let the jury try it on. Let them see what it's like to have to wear that on their knee for 4 minutes, 1 minute, and your client has to wear it all the time. Anything you can do to cross the bridge from somebody else's pain to a pain the juror personally understands with. Because what we're accustomed to doing in everyday life is when someone else is in pain, we distance ourselves from it. You know how human beings distance themselves from the concept of death. We don't really like to confront the fact that we are all someday going to die, and I'm sorry to have just reminded you. But we do the same thing with pain. We distance ourselves from pain. We don't imagine what it's like to feel what they're feeling. So you need to do some work to bridge that gap. And how to do that is a little more help in the book. and certainly a lot more than I can provide in the 3 or 4 minutes. But that's a fundamental thing that makes an enormous difference. And I would start, if I were you, especially if you're relatively new to the practice, start looking at the closings, maybe the openings too, of the lawyers who do really, really well when it comes to damages. And try to spot what are they doing that helps them cross the membrane, like the blood-brain barrier, that helps them cross the membrane from someone else's pain to the juror themselves, bearing in mind to never say to a jury, how would you feel if this happened to you? How much money would you want? Don't do it.
Absolutely groundbreaking. I remember when I first learned that from you, jurors don't give money for pain, just the pain alone. That, wow, doesn't that go against everything I thought I knew? And it does. And it's one of the reasons that your advice has been so helpful to me and so many others. Jurors aren't going to give money for pain, but they will give money if they see how that pain affects someone, how that pain changes them, and what good giving the verdict is going to do. Can it help take away the pain? And if not, what good does the money do? Which is
there's a chapter on damages evolving that deals with what good does the money do that might be useful to look at in that regard.
Today's tip comes from David Ball on Damages 3 by David Ball. And here to read it is David Ball.
Good morning, everybody. Good morning, Michael.
Good morning.
Most jurors expect a defendant to have acted the way most others in the same position would have acted. The more you show that a defendant violated that expectation, the more jurors are likely to gauge the defendant's conduct as wrong. Jurors gauge conduct by the norm.
So this is a great tip because it puts in different language what every jury instruction says, right? What is reasonable care? And it's what the reasonably careful person in a similar situation would do. But we don't have to use that language exactly. We can talk about it in a common sense way. That's what I hear when I hear you read this.
And you need to be very careful with this. If you think about it, you'll realize this is one of the very few places in law where someone's subjective judgment is determinative of outcome. Usually the law expects you to be logical and objective, which is the opposite of subjective judgment. It discourages that. Here, the law on negligence invites the jury to use their subjective judgment of what the right thing is to do in the situation the defendant was in. And that means you need to show the jury what the expectation is. Some product defense laws, product liability laws are the same. Did the safety of this product meet user expectation? Which means you've got to try to find ways to show, for example, it become a great jury selection topic. What do you expect in such and such a circumstance? What do you expect a company to do? What do you expect a driver to do? What do you expect a physician to do? And then take those answers and use them as the normal frames for what you're showing this defendant did not do in that case. I expect them, some jurors will say, to follow the rules they're supposed to follow. Hence, Rick Friedman and Pat Malone's book, Rules of the Road, which shows that they did not follow the rules that jurors would expect them to follow. The jurors don't have to know those rules, they just expect them to follow the rules. And insofar as it's not just that it's a rule, it's that somebody moved away from that rule. I expect them to follow that rule. That won't be true of every juror. There'll be other standards of what you expect of somebody in that situation. So I think this is all this does is take the instruction really and move it into why that instruction is public policy, what it is that we demand we need, which is why framing it this way in your mind, little note on your desk, how can I show that what they did violated, stepped away from, did not meet the expectation that we all have of somebody in that situation. And a great jury selection question is think back in your, I'm making this up as I go along, but think back in your life too. Can you think of people who violated an expectation that you had of them, that you felt people should meet that expectation? So you get some feeling for where jurors come in on that level. Do you meet the expectation, or for some selfish or other kind of reason that you say, the hell with what you expect, I'm going to do what I feel like doing?
I think that's exactly right. This is great wisdom, as always, from your book. And I would like to add, just personally, how your book and all its different 1, 2, and 3, how important it's been to me as a lawyer. And I suggest to everyone, if you don't have it, get it. It's easy. And if you have it, go back and read it, because every page of your book, every paragraph has something, like you just said. You can read about the standards and the rules, and you can take off on that, like Rules of the Road did.
Yeah.
There's so much wisdom in your book. I suggest everyone go back and read it.
I would expand on that a little bit. Take the books that you have found valuable and take a day long before you expect a trial to come before a jury, and just quickly leaf through. Hopefully you highlight or underline as you read. Just leaf through those books. It'll take a day if you have 5, 6, 7 books that you really like. Just take a day, or notes from seminars, whatever. But we lose 90% of what you've learned. You'll lose 90% of what you've learned, aside from the fact you'll see things you didn't see before. But when you go back over, you say, oh yeah, I remember that. This is going to be dead on right in this case. You don't have to reread the whole thing. Just leaf through it all. It seems like plotting, but I'm told people that do it, because it works for me when I'm reviewing for something I need to review for. And everybody I've talked to who's done it says it's one of the most valuable things they do. Go back through all that wonderful information you've gathered and make sure you're mining it now for how can I use it in this next case. Don't lose what you put all that time and money into gathering.
Today's tip comes from the video, Winning the Unwinnable Case, Key Techniques for Every Trial. And this is by David Ball and Gary Johnson. We have David Ball here to read it for us. Good morning, David.
And full disclosure, before I do, I am certain, though this is many years ago, I can hear Gary, who to me is one of the geniuses in the world. He's a kind of legendary lawyer in Eastern Kentucky, Pikeville. I can hear Gary saying these words, and they are, there is nothing more powerful than believing in your case with every fiber of your body. You cannot be shaken if you believe in the justice of your case. Do not try a case you do not believe in.
Yeah, absolutely. And if you haven't heard Gary, he is a wonderful lawyer. Get this video. This video is great. He goes into some details of strategies of cases the two of you worked on together. So what about this? This just resonates with me as deeply true. Believe in your case or don't take it. It's one of the rare things that the plaintiff has over the defense. We get to choose the cases we want.
It's a big deal. And it's, when Gary said this, I mean, this would be 10, 15, 16, a long time ago. And it's kind of a precursor to what we're seeing more and more of today, like Michael, your Zen book, like Nick Rowley's Trial by Human Material, where Rick Friedman's book, Beyond Technique, where after all is said and done, the human being that you are and what you think and what you believe and what your values are in terms of the case in front of the jury, we're seeing finally how incredibly important those things are. And I ignored that for years. There's not much of that in my earlier books. I was an engineer, but ultimately you're not an engineer. Ultimately, you are the person doing this thing. And when you're in front of somebody who truly believes something, and then can show you why what he believes in is true, you've got a credibility that can survive. You got overturned on some objections or whatever. Not everything in the case went through it. Your focus, your person that you are, is working on behalf of. I don't like fighting because I don't like turning trial into a battle. I think that's the wrong mindset. It's a campaign for what you honestly believe, for what is true. So that when you give even your outrageously high figure, if you do, the juror's impression is this is something you truly believe and not something you're trying to maneuver them into. I think it's extraordinarily important advice from Gary. I almost feel bad that it's hit. If you just look at the heading, this looks like something I said. I wish I had said this back then. And one of the things that Artemis and I do when we work with the lawyers we work with, if somebody's going to call a consultant, it means to some degree they're insecure about whether they can win their case or not. You also need to be considered, while you always know you can lose, you need to be convinced that you can win this damn thing after all, looking at all the warts, all the horrible things that are wrong with it. The truth of the thing is something for you to make yourself part of. And there's no quick way to do that. Read Rick's Beyond Technique. Read Zen. What's the whole title? I had the book sitting over the wall, whatever. What's the title? It's a full title of
it's the Zen Lawyer Winning with Mindfulness.
That's right. Zen Lawyer. Just go to Trial Guides. You'll see that. I strongly recommend that, Rick's book, other things that get you into the world of truth, empathy, putting yourself in the shoes of the jurors who were listening to you, of your client who came to you, even of the defense attorney who's fighting you. So that the best parts of the human that you are, I'm not trying to change you, the best part of the human that you already are starts becoming the thing that's on the threshing floor in front of the jury. And that starts with a belief in the justice of the case, not a belief in the skill of your method. You need both. But the true belief is in the justice of the case.
Yeah, believing in the justice and believing in the jury. I know some lawyers that will, I know there's debates about selecting and deselecting juries and jurors, I should say. But I think to be a trial lawyer, a really effective one, and to believe in the case also means to believe in the system and that jurors will do the right thing when you give them the chance and guide.
And when they don't, you could have gotten to them if you'd done it. In other words, don't blame them. It doesn't, first of all, it doesn't do you any good. And second of all, I learned this from Eric Oliver, a great consultant in Michigan years ago, also a very dear friend, who said, you got to try your cases if you ended up with the worst jury on the planet. And he's right about that. You can't blame things that you can't control because that never helps you. How can I look at the things I can't control and do what I need to do anyway? And this little tip from Gary is one of the ways to do that.
Today's tip comes from the classic David Ball on damages by the classic David Ball, who's here to read this for us today.
And I will read this in my most classical intonations. Jurors tend to give more money when they see that the defendant's wrongdoing was a failure of responsibility and that the defendant continues to try to evade responsibility in court. Negligence is a failure of responsibility by definition.
So, tell us more about that. I'm just trying to kind of take that into an example.
Well, negligence always is a failure of someone's responsibility. Regardless of why they did it, that's ultimately what it is. Now that maybe they should have learned their lesson, yet they repeat the act of evading responsibility, failing responsibility in trial, it becomes a double punch. Because now the jurors have a double reason to want to make sure that that defendant does the right thing. Now, be very careful here. Do not say that they're evading responsibility by forcing this to come to trial. That can get you overturned and has in a lot of cases. Don't say that. Just say, here's what it means to be responsible in this kind of case. And that'll be very different from what they're willing to do. It means not just saying you're sorry, it means making recompense, however you want to frame that article. But don't say, by coming to court, they're demonstrating their lack of responsibility. Instead, show how the very defense is an evasion of responsibility. When they bring in an expert who does not look at all the information before coming to a conclusion, that's evading the responsibility of an expert. When they, et cetera, et cetera. So you've got to walk a fine line here, but it's worth learning to do, because that is the jurors don't like people who intentionally, knowingly sit in a room and deny their responsibility to them. That's a worse act to jurors than when you miss your responsibility by going through a red light or, doing whatever you did. So it helps the jurors see that they're not dealing with a good force on the defendant's side, and that all your side is asking for is the normal human, meet your responsibility, which means to make up for the harm you did.
And you mentioned something, many things that are really important, but the idea of the wrongdoer evading responsibility in front of the jury, that this is a trial, and it's important that the jury experiences that. And whether that means you have the corporate representative and you say, this is what you did, do you take responsibility? Or in any other way, how do you suggest we do that? Because that's so important.
Well,
right?
one of the ways is this company is still saying that what they did was okay. Rather than accepting the responsibility for hiring a driver with that kind of driving record, they're still here in trial saying it was no big deal. That's, it's okay. They're still saying that. That you've never even used the word responsibility, but the jurors know what that's about. I don't care if the word responsibility goes through their head or not, but it means that the jurors themselves become the victims of the bad act. It's like the try the lie thing. If there's a lie in the case that the defense told somewhere along the line to the plaintiff, use that. Yeah, that's okay. But it's not as good as a lie that the defense lays on the jury. Because when you make the jury the victim of the bad act being evasion of responsibility, or the lie, or the deception, that villainizes everybody sitting on the defense side of the room. Not just some trucker who didn't get enough sleep and went out on the road and drove and hurt somebody. That way expands it. And you don't have to say any of that. You just make sure you say things like, they're still saying today that what they did was okay. Or they're saying that these consequences that you've seen are trivial. After hearing what they've just heard, they will still say, no, that's not as precious, as valuable, as great a harm as they're saying. Those are evasions of responsibility. And it villainizes, without you using the word villain. You don't want to do that. Let the jurors come to those conclusions. Give them the materials, give them the information, and the jurors will get there, enough of them anyway. So if there'll be that thrust to provide a proper verdict. Don't ever ask for more money on that grounds. That'll get you reversed or stop dead anyway. It's that what I'm saying is it drives the proper amount of money. And you can say that. when you close. Despite the fact that they trivialize what happened here, despite the fact that they're saying what they did was okay, your verdict should encompass the full and fair amount of the harms and losses in the case.
Today's tip comes from David Ball on damages, and we have David Ball here to read it.
If you leave the jurors alone on the topic of harm and damages, they will return the favor.
So we are so lucky to have you here today, David. I think that lawyers forget, or maybe lawyers now have been practicing since your book, David Ball on Damages, came out, and how groundbreaking it was for you to say what is so obvious to so many of us now, which is talk about the damages. That's what you're there for, to get a verdict, and don't ignore the damages. But until you came along, a lot of people were ignoring them. So I know that we're now many decades into your good advice. And as that's evolved, what more can you tell us about that, about not leaving damages alone?
Well, the first rule of any kind of presentation, be it from a lawyer or a play or a movie or a sermon or anything where you are presenting stuff to people who are dancing, dance, music, a trial is about whatever it spends its time being about. And there's a very strong characteristic of the brain. It's called a bias, but I don't like using that word because bias always means something negative. Simply is this. When we make a decision, we use the information that's been running around in our brains just a little while before we have to make the decision. So if you leave out of all that information the damages, the harm and the damages, there's no way that that's really going to help you drive damages. And in some cases, that's fine. The negligence has been so outrageous that that's going to do all the driving. But in 95% of cases, it's not quite like that. And you still need a substantial foundation of damages. And you're right. When I came along and started doing this, one of the first things I noticed is people would do an elaborate opening or a whole trial about liability. Did this cause that? And you shouldn't have done this or done beautifully. And so at the end, we're going to come along and ask you for some money. Okay. People were afraid. They're still uncomfortable asking, making the ask. And yet that's the only important reason you've gone to trial. That's why you went. Otherwise, why on earth would you go to this trouble? Why would your client go through all this agony of reliving the awful thing that happened? When that's what's on their jurors' minds, one of the harm and damages, harm and losses. I usually use that phrase harm and losses because that covers everything there is to damages, but you don't have to. When that's one of the things that's in the jurors' minds, that becomes one of the reasons, one of the bases on which they come to their decisions. And you countless times hear jurors say, either in focus group deliberations or talking to them after trial, you frequently hear them say, I feel bad for the defendant because really all they did was take their eyes off the road for a minute, but look at how they left this poor person. That's totally a damages driver. That's where they didn't even think it was very bad to do what the defendant did. So it's very important, I think, to make sure that you learn everything you can learn. And at the time, this book on damages was the only thing out there. There was nothing else. And what I love about when I look back at my 30 years in this business, honey, when I look back at all that, there's been sort of a blossoming on stuff about damages, leaving lawyers with all kinds of tools to be able to pursue damages. Don't just walk in and think, oh my God, I feel bad for my client, so they will too. No, you have to help them. That's what it means to be an advocate. You are speaking for the pain and the suffering of your client. Advocate needs to speak for. It's not you're just speaking for your client, you're speaking for that pain, suffering, the agony, whatever it is. So that's what this is about.
Wonderful. A way to be a true advocate, to really embody what your client's gone through and bring it to the jury. And like you said, a lot of the work since your book came along and now, all the trial guides books and other writings out there really have to do with the lawyer being comfortable asking for the money, owning that.
It's asking for the money, and it's being comfortable, not just comfortable, but intimately familiar with your client's life, particularly in large cases of highly catastrophic injury. But even with smaller, jurors sense when you're acting like an accountant when it comes to the harms and the losses. They feel that. There's this, and then there's that, and then, oh, by the way, there's this over here, and don't forget to put this on the ledger, as if you're someone's accounting, saying, here's your profits and losses for the years, rather than you're talking about somebody you know intimately. You're talking about somebody who actually personally means something to you. Your empathy for your client will transmit to the jury when you're talking to them. And your lack of empathy, real feeling for what that person's going through, will also convey to the jury. It's just like a good actor, as opposed to an actor who just stands there and recites his lines. You want to be the good actor.
I'm here today with David Ball to read today's tip from his classic, David Ball on Damages, which is now in its 3rd edition.
Juror anger. Juror anger is our best antidote to tort reform. Tort reform is not a phrase we hear as much today as we did in 2010, I think, when that book was written. You don't hear the term as much because the defense and the insurance companies have wised up and used that term less. But the forces of tort reform, of showing that you're evil, that you're greedy, that you're going to drive all the doctors out of state. This year, there are going to be several state initiatives come up to put more caps, remove limitations to what you're allowed to ask for in damages because of the tort reform movement. This stuff doesn't just happen by itself. You're going to get into trial, and it's no longer tort reform as a lobbying thing that they use in legislatures to limit what you can ask for. That's a different area that people need to work in, and thank God for the trial lawyer associations, the associations for justice that are dealing with those things. Not to be able to ask for doctor bills, maybe in some of your cases. But once you're in trial, that feeling of anger on the part of so many people about what you lawyers do, terrible things. You're making a living on the suffering of other people, and the cost to us all is enormous, and that's why insurance rates are so high, and I have to use a PA and not a doctor, et cetera, et cetera, et cetera. They blame it all on you. That's even why Big Pharma is such an evil force, because your lawsuits have driven them to be evil forces. Go figure. But you can't fight the public policy battles in trial. You can, however, fight for your jury. And the one thing that will offset, not the one thing, one of the things that will really help offset the anger against plaintiffs' lawyers in general and the system in general is there's an anger at what the defendant has done caused the injury. If you frame it the right way, we don't want you getting angry at the jury or in front of the jury. We don't want you displaying your own anger. That's like watching a little kid have a tantrum. Don't do it. We want you to present and frame the information to the jury in ways that gets them to be angry. For example, consider the fact that every act of negligence, whether or not it causes harm, every act of negligence that is done when you're not alone, every act of negligence is an act of disrespect of other people. And one of the worst things you can do is to disrespect other people. And when you disrespect the whole damn public by who you hired to be a driver for the truck, or by how you drove your car, or by how you did that surgery, whatever it is, you must respect the people who depend on you to simply exercise ordinary care. And when you frame it that way, then you start to get the jury angry. Let me give you another example. I'm sure you've heard the phrase, try the lie. Well, I think what's clear by now is that jurors don't really mind lies. I would cite political proof of that, but that's not what we're doing here today. But jurors aren't really that exercised when they hear about lies. What they cannot take, and what they will get furious at, is when they feel that you or your witnesses are lying to them. So it's not enough, for example, just to show that the defense causation doctor is wrong. That's nice. That's useful. It's necessary. But that by being wrong and trying to foist it off on the jurors, he is disrespecting the jury. May not be able to say it in exactly those words, but you can come pretty close. There's a section in just stuff and damages, and there's other stuff in the damages evolving book about how to take expert testimony and get the jurors furious that the defense is even putting that stuff on. And that's where the kind of anger comes from. Let me end with the same caution. Your demonstration of anger to most jurors is like watching a nasty, irritating child have a tantrum. Don't do that. Stop telling jurors what to think and feel. Stop demonstrating it. Give them what they need to do it themselves, and they'll do it. Push it down their throats by you showing it, especially on cross-examination, but really anytime. And they will rebel against that. It's simply a human reaction. Irritation and anger in our face is just annoying and will distance. But when you can get their anger directed at the defendant, that remains, after all these years of court reform, that anger remains one of the top 2 or 3 drivers of damages. That's why you can go way beyond what the usual verdict seems to be, usual damages verdict seems to be for quote cases like this.
Listen to David and take this in. This is huge. So it's easy to say, yeah. I know every time I read your book, I get something, oh yeah, that's what you mean by that. So what you just said is anger can motivate a jury verdict, but it's the juror's anger, not your anger. And when you put the anger in the room, you take it away from the jury. So that's huge. What you just said, I see a lot of trials where lawyers break that from the onset. So if you come in and your opening says, look, they lied in their deposition, all you're doing is whining, versus put that witness on first and let them lie to the jury. That's a huge difference, right?
Well, what we do with experts is you learn the protocol for whatever the analysis was they were supposed to do. It's always a more intricate protocol than you think. And you have your own expert on. You go first to talk about each thing that he's required or she's required to consider and gather all the information and then do this, that, and the other thing. It's not that complex. There's just a lot of it. And explain by why each one of those things is important. And that every single person in this field is taught this from the time they take their first courses on it all the way through their careers. These are the things you need to do to find causation. In criminal cases, to decide which way the bullet came from or whose DNA or what, well, anything, there's a protocol. It's not like what I was being an English major. There's no protocol. And in fact, Dauberg requires, because you have to use a method, recognized methodology that always includes like a checklist. And when you don't do that, you are able to bend the verdict, bend your opinion any way you want. And when the jury can come to that conclusion on their own, they will punish the lawyer who sponsored it. if you give them the information. They can't tell on their own that the causation doctor violated the fundamental precepts of coming to a diagnosis. The jurors don't automatically know that. People don't know, the layperson doesn't know it, but it's knowable, and you can learn it, and you can use it as the foundation for really good crosses where you sit there being very professional and very calm and let the witness hang themselves and cross. And
Great wisdom.
His realization is they lied to us.
Great wisdom. Thank you so much for today's tip, David.
Sure, Michael. Thanks for letting me.